In early 1917, the First World War was raging in Europe. The United States had adopted a policy of neutrality, although it was sympathetic to the Allied forces of Great Britain, France, and Russia. However, after Germany resumed unrestricted submarine warfare, and after a telegram was intercepted detailing a German plot which promised portions of U.S. land in return for Mexico joining the war against the United States, President Woodrow Wilson asked Congress to declare war. On April 6, 1917, the United States officially declared war against Germany, entering what was one of the bloodiest conflicts in recorded history. The Selective Service Act of 1917 called for all men ages 21 to 30 to register for military service. Congress later amended the law and expanded the age range to include men from 18 to 45 years of age. In order to protect the war effort, Congress also passed the Espionage Act of 1917.
The Espionage Act is an effort to try to make sure that criticism of the government and criminal acts taken against the war effort wouldn't be tolerated, would be prosecuted by courts of law.
Well, it was a serious act. They up to 20 years in prison for a violation, and there were a variety of ways that you could violate it. One way that you could violate the act would be to do anything, speech or otherwise, that would obstruct military recruiting or that would really discourage military recruiting. And it was enforced with extreme vigor. I think over 2,000 people went to prison for violation of the act.
Charles T. Schenck was the General Secretary of the Socialist Party of America and was opposed to United States participation in World War I. Schenck printed and distributed 15,000 leaflets which encouraged draftees to peacefully resist the draft.
One side of it printed the 13th Amendment. The other side said the draft violated it, and it called for petitioning the government, for trying to get change. It said, quote, "Do not submit to intimidation. If you do not assert and support your rights, you are helping to deny or disparage rights which it is the solemn duty of all citizens and residents of the United States to retain."
No calls to rise up against the government. There were calls to disobey the Selective Service Act. There was no evidence whatsoever that these circulars had that effect at all. I mean, if you're getting mail from a guy named Schenck, who's the General Secretary of the Socialist Party, who's Schenck, right? So there's no showing that there was any effect from the mailing of these circulars. But clearly, Schenck wanted to disrupt the draft.
The leaflets were traced back to the Socialist Party headquarters, and although Charles Schenck denied distributing them, he was placed under arrest and charged by the U.S. government with violating the Espionage Act of 1917.
The courts tended to apply what was called the bad tendency test. That is, if the speech in question had a bad tendency, that is, if it were likely to lead to some conduct that the government ought to have the right to prevent, then that's enough. And that's all we need to show in order to prove a violation of the Espionage Act, which prevents obstruction of the military draft.
The government's position is, come on, if you appeal to people, you appeal to their conscience, they may not feel as good about going to war, and they may decide not to go at all. And the government saw this as an obstruction, and the court said, well, this is an evil because it tends to interfere with the government's goal, and the government has the right to suppress that.
The district court found him guilty of violating the Espionage Act, said that his First Amendment concerns were immaterial, that the First Amendment protected only against prior restraints on publication. That is to say, they stopped you from publishing something that could violate the First Amendment.
Having been found guilty in a U.S. district court, Charles Schenck appealed his case to the U.S. Supreme Court. After considering his appeal, in 1919, the court agreed to hear the arguments in Schenck v. United States, where it would answer the following question. Is a leaflet sent to draftees when the nation is at war, urging them to peacefully resist the draft, protected speech and press as guaranteed by the First Amendment?
The First Amendment had been part of the Constitution for almost 130 years by the time that the Schenck case came before it, but the court really had never addressed it in any meaningful way. So Schenck was able to focus on the First Amendment and basically argue that a law that prevents arguing against the draft, indeed for arguing for opposition to the draft by completely legal means, should be a violation of the First Amendment, which says that Congress shall make no law abridging freedom of speech. So it was a pretty straightforward argument. The fact that you're trying to send me to jail for up to 20 years for speaking ought to violate the First Amendment.
The government's argument was that this was a legitimate exercise of the government's war power, that when a nation is committed to war, it can take actions that further the successful prosecution of that war, because you don't go to war to foster civil liberties per se, you go to war to win a war.
In a unanimous decision, the justices of the Supreme Court upheld Charles Schenck's conviction and ruled that the Espionage Act did not violate the First Amendment. The court reasoned that the leaflets, if distributed during peacetime, would be considered a harmless exercise of free speech. However, the court ruled that those same leaflets, during a time of war, could prove destructive, potentially interfering with the military's ability to achieve its goals. In his now famous written opinion, Justice Oliver Wendell Holmes explained,
"We admit that in many places and in ordinary times, the defendants, in saying all that was said in the circular, would have been within their constitutional rights. But the character of every act depends upon the circumstances in which it is done. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. It is a question of proximity and degree."
What the court basically said was circumstances. If we believe that the words or the speech will have a tendency to create a clear and present danger, that is, to obstruct or interfere with basically a legitimate goal of Congress, we, such as prosecuting this war, we believe Congress can suppress the speech.
The second thing about Schenck that's significant is that it's the first time the Supreme Court authoritatively said that the First Amendment's protections go beyond simply limiting prior restraints, that they protect speech more generally, in particular, political speech.
The assumption from the very beginning, and Schenck is the very beginning of our First Amendment jurisprudence, is that speech can cause harm. We don't protect freedom of speech on the theory that sticks and stones can break your bones, but words can never hurt you. Holmes recognizes, and the court has always recognized, that words can do a good deal of harm, and that's why the government, at least in some instances, has the right to regulate or prohibit or punish speech. Now, the other point about this clear and present danger test, it's a very, very famous test that was used to evaluate what we call seditious speech. That is, speech that is aimed at either overthrowing the government or causing some sort of violent harm to government interests. It's not the sort of test that would be applied, let's say, in a case involving defamation or obscenity or commercial speech. It's really a very narrow category of cases that it ever applied in to begin with.
Following this historic ruling, Charles Schenck returned to jail, where he served 6 months for violating the Espionage Act. The clear and present danger test would continue to be used in various cases for nearly 50 years. It wasn't until 1969, when the court heard the case of Brandenburg versus Ohio, that the court adopted a new standard for judging freedom of speech.
The current standard governing free speech, political speech, which is what Schenck was engaged in, is the clear and imminent danger test, which protects more speech because you have to show that there is a danger that's going to happen right away. So the version of the clear and present danger test that is applied in Schenck no longer exists as a matter of law.